very difficult time. I've never.
And I've got an admit here I've got to do. Let's see. Jamie, do you have control also of the screen to admit people, or should I be doing that?
I have control, and
Okay.
I'll take care of that.
Is the rabbi.
Yeah. So
I'm going to myself now.
it's really a great personal joy to be able to have a conversation with members of my community, with being with people who I care about and enjoy learning from and enjoy speaking with. So appreciate the opportunity to do this. I have a professional background in the Constitution. This is, everybody probably knows that a lawyer begins by going to law school. You complete that course of study with a Juris Doctorate, which is a doctorate of law. And that's a terminal degree. That's the furthest that you go in that academic pursuit as sort of an acknowledged academic, but you continue on in that area if you'd like to by becoming a professor or doing other academic research. And following graduation from law school, and in law school, one of my specializations, probably my single greatest specialization, was constitutional law with an extension into international human rights. So United Nations and international treaties, things around human rights. Following that, I went to Israel and I studied some comparative law. I was in a yeshiva and was in discourse around secular law, so the United States Constitution, and then Jewish law around that. And around 2004, following some efforts that CBE led around conversations with the, in multi-faith conversations following 9/11, including Islamic leaders, Christian leaders, and Jewish leaders, members of those three faith communities, began speaking over at Colorado School of Mines and was invited to join their faculty, where I taught a number of different law courses. And currently, my area of focus and concentration there is constitutional law. So every Monday night, last night, for example, I teach a 3-hour course, 3-hour lecture course. It runs about 15 weeks, their full semester. And I also teach a related course, actually, called Intellectual Property for Engineers and Artists at the Colorado School of Mines. And that actually ties directly into the Constitution, and we can talk a little bit about how inventiveness and art relates to the Constitution and why that's a constitutional value. So I want to back up and begin by just talking to you a little bit about the background of the Constitution, what kind of document that it is, and what it represents, and how it differs from, other legal traditions. So first of all, if we just think about the root of the word democracy, and Joanne or anyone else knows these all too well, I'm sure. You have two Greek words, demos and kratia. So demos meaning people, and kratia relating typically to the word rule or to the word power. So right at the center of this legal tradition that we have is demos kratia, or people power. And you can use that as a jumping off point, because when you think about other legal structures, you might think about theocracies. So those are legal systems where people believe that they can speak for God and legislate the affairs of human beings by having God's voice as some kind of an authority, or some document as kind of an authority. You have monarchies, for example. Those are legal traditions that stem from the idea that the sovereign is an inheritable right, that it comes through a bloodline that descends into lines of kings and queens. You can have autocrats, right? You can have dictatorships, all sorts of ways that law gets promulgated. But the United States legal system really comes out of a Enlightenment and post-Enlightenment period of time where we conceive of something called natural rights. and corresponding to natural rights, a social contract. So this becomes the idea that it gets written about by a number of different persons. It gets translated very well by John Locke, folks who are in the generation of those who are considered founding fathers, Thomas Jefferson, John Adams, Madison, those types, are students of John Locke's. And in fact, we get the Declaration of Independence as a document that sort of animates the basic idea set around this social contract in the United States and the development of the United States Constitution right out of John Locke. And I want to show you this because, may I borrow your screen, Jamie? So I believe.
You should be able to screen share.
Yep, okay. So let me go ahead and do that. And I want to begin here with the Declaration of Independence. This is just fascinating to me that when we begin to speak, and can everybody see it? Am I sharing the screen, Jamie?
Yes.
Okay.
Good.
So this is the actual document that when we talk about the Declaration of Independence, that it is written by human beings in their own hand with errors and penmanship and those sorts of indications of human creativity or human effort and endeavor. And I've only got parts of it clipped here. This is actually in Jefferson's primary hand, and some of the edit marks are from other founders. But it begins, let me move something out of the way on my screen so I can show you. So it begins here, when in the course of human events. Most people, when they think about the Declaration of Independence, they think it begins, we hold these truths to be self-evident, right? That's what everybody knows. We hold these truths to be self-evident, all persons created equal, endowed by their creator, and so on. But it actually begins here, when in the course of human events, it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth the separate and equal station to which the laws of nature and of nature's God entitle them, a decent respect to the opinions of mankind requires that they should declare the causes which impel them to the separation. So this is Jefferson's way of writing a Dear John letter to King George. And he's saying, listen, we just have an obligation to have good manners and to set the record straight for mankind. But what it tells us right away is that he is interested in politics. So politics understood, again, in the Greek sense of the affairs of man within a city-state, right? So he's not premising this, that there's, so in Judaism, we have, the Abrahamic covenant, right? We have a covenant with God. This is really expressing the idea of a covenant between men, not a divine covenant, but a political covenant. But he builds into this idea right here that somehow or other there are these things called laws of nature and of nature's God, right? Somehow or other that these are out there. And he expands on this idea in the second paragraph. He says, we hold these truths to be self-evident. All men are created equal, endowed by their creator. So again, the premise that you have some kind of a priori set of divine rights. So we hold these truths to be self-evident. All men are created equal, endowed by their creator with certain unalienable rights. In other words, rights that can't be taken away from you. And then he says, among which are life, liberty, and the pursuit of happiness. And among which is really important when it comes to interpreting the Constitution, because it's not just that you have life, liberty, and the pursuit of happiness. Those are three big ones, but there are others. There will be others. And the idea, by the way, in this phrase, life is this biological thing that we have, this experience that we have as mortal beings. Liberty is the essential operative question of the Constitution when it comes to civil rights and civil liberties that we have considered from 1776 all the way through to 2020 and will continue on. the pursuit of happiness is really a Greek idea of eudaimonia, of this idea of fulfillment, that it doesn't mean happiness in a kind of conventional sense that we use it now. Are you happy? In other words, are you feeling joy? But it could be that you're even suffering, right? That you're an author or an artist or a musician who's suffering for your art. That might be your own pursuit of happiness, your own pursuit of what the Greek sense of fulfillment would be. I'm sorry for coughing. I know that's annoying. So the Declaration of Independence is not the Constitution, and apologize to if obviously most people know that. So the Declaration of Independence is not at all a legal document. It is not going to be the source of any rights, nor will it be the source of any powers. The Declaration says that all people have these certain unalienable rights, but the next part of it says governments are instituted amongst men to secure those rights, and they derive their just powers from the consent of the governed. So this becomes the idea that I've mentioned of the social contract. So every single individual is born with unalienable rights, and in order to protect those rights, we create a constitution by giving powers to this new sovereign, this new entity called a government. And only a just government is reliant on the consent of the governed. So this is a social contract. In other words, it's a moment of ascension where we agree to this bargain. And the legitimacy of this government is only based upon its role in protecting your rights. So as a constitutional, as a gesture of constitutional interpretation, we always begin with the idea that you have your rights, by the way. They don't come from the Constitution, they come from the Creator, they're inalienable. And you don't have a job to the government has a job to you. The job to you is to protect your liberties. And the philosophical premise of this is, you can look at it as Hobbesian, right? Where Hobbes believes that man in a state of nature is very subject to the perils of losing their unalienable rights because, according to Hobbes, life is nasty, brutish, and short. You can't rely on your fellow man to be good to you. So it's kind of this dismal view of human nature, that man in the state of nature is not going to be fruitful in terms of protecting liberty. So we have this social contract. You have rights. We give power to the government, which brings you then to the Constitution, which is essentially, here it is, right? Here's the Constitution. But let me simplify it. The Constitution is written in 1787, shortly thereafter ratified by 9 and ultimately 13 states. It is a document that sets out powers. So it has a few articles in it. It's really short. Article 1 begins with the phrase, all legislative powers herein granted. So it is a grant of powers by we the people, right? Here at the beginning of this document, right? This is the United States Constitution. I'm moving my screen so I can see it better. So it also begins, we the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and to our posterity, do ordain and establish this Constitution for the United States of America. This is considered to be the preamble of the Constitution. When I say that, here's what you need to know. This has no legal effect whatsoever. You can't go to the Supreme Court or to any court and claim that the government is not doing its job because it's not acting in accord with the preamble. So it's not the source of rights, nor is it the source of power. It's a mission statement. Here's what we're trying to do. And looking at it as a mission statement, though, it does give us some clue about what this social contract that we've engaged in is all about. First of all, we are forming a more perfect union. So this is essentially something that has a bit of humility knit into it. We're not establishing a perfect union, and we're not right. So this is something that even implies quite directly change, right? We're in the process of perfecting the union. And what do we want to do? We want to have justice. We want to have peace, domestic tranquility. We want to provide for the common defense, right, to protect our nation. We want to promote the general welfare, and we want to secure the blessings of liberty to ourselves, but not just to ourselves and our children. And so we do establish a constitution for that point. and that is, friends, how we get to this point. The Constitution then is a document that has to be interpreted by a Supreme Court. So it's interpreted within the context of saying, all right, it's a social contract that grants powers. And we know, first of all legislative powers are vested in the Congress of the United States, which shall consist of a Senate and a House of Representatives. When the Constitution in Article 1 says all legislative powers are granted to the Congress, it's telling you that the courts are not to have legislative powers. It's telling you that the executive branch is not to have legislative powers, that laws that govern the conduct of persons within this country at the federal level are going to come from these Article 1 powers. Well, then it goes out and it tells you how we go about choosing people, and it tells you how many members of the House of Representatives there are going to be, and how many members of the Senate there are going to be, how old you have to be. You got to be 25 to be a United States member of the House of Representatives. You serve for 2 years. You have to be 30 to be in the United States Senate. You get to serve for 6 years. And once they seat the House of Representatives and they seat the United States Senate, they then tell you what kind of powers this government can exercise, because this is not an unlimited grant of power. This is a limited grant of power. So you and your 330 million fellow Americans have granted power through the Constitution to the Congress to do certain things. Now, you may want them to do lots of things. You may want them to do all kinds of things, but if they can't find the power in this document to do them, then they're not allowed to do them. That would be an unconstitutional act. So each time the United States Supreme Court evaluates an act of the federal government, an act of legislative power by the federal government, they're going to come back and ask, well, did they have the power to do this? And they don't always have the power. And those acts, even good ideas, even great legislation, noble legislation, legislation that's incredibly popular, legislation that passes 435 members of Congress, 100 senators, and is signed into law by a president, can be challenged by one grumpy person who says, yeah, but it's not constitutional, it's not part of the power. So here are the kind of things that the framers thought the Congress should have the power to do. And you're going to see it's often about money and very little about social issues, right? It doesn't talk about marriage in here. It doesn't talk about voting in here. It doesn't talk about most of the things that you do all day. It says Congress can lay and collect taxes, right? There's number one, money. Number two, it can borrow money. Well, it's gotten good at that. Number three, so the first two are already about money. The third one, to regulate commerce with foreign nations among the several states and with the Indian tribes. So again, regulating commerce, only interstate commerce, by the way. Number four, to establish a uniform rule of naturalization and laws on the subject of bankruptcy. So basically citizenship laws and bankruptcy laws, again, about money. The next one, to coin money, in other words, to print money, and to regulate the value of the money, again, about money. To provide for the punishment of counterfeiting of the securities and current coin, again, about money. So these are the things that the government is all about. And then we move on and we say, they're also going to make post offices and post roads. The next one gets a little more interesting, to promote the progress of science and the useful arts. That's establishing essentially copyrights and patents for artists and inventors. The next one is to create courts inferior to the Supreme Court. We're going to see that the third article of this document creates the Supreme Court. This gives Congress the ability to create the appellate courts, which are below the Supreme Court, and the district courts, which are the federal trial courts. And we can go on. It defines piracies and felonies committed on the high seas, to declare war, to raise and support armies, to provide and maintain a navy. You'll see in here that you don't have a space force or an air force provided for in the Constitution. I bring that up because it shows you that things change and the interpretation of the Constitution has to change. To make rules about the military, right? Regulation of the land and naval forces. The next one, you actually see the militia word come in. So for the people who have questions about the Second Amendment, this is the first time you see the word militia. To provide for calling forth the militia to execute the laws of the Union. That's because in the period of time between 1776 and 1787, this country didn't have an army or a navy. What we had were the different state militias, which are now, they've become the National Guard. They're what's known as the National Guard. They're under the jurisdiction of your respective state governors. The next one again deals with the militia, to provide for organizing, arming, and disciplining the militia when it's called into service by the federal government. This part has to do with legislating Washington, D.C., and that's it. The last section is to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by the Constitution. So any other laws that are necessary and proper for the prior powers are permitted to the Congress. That's it. That's what your government is supposed to do. So when we talk about exercising power, the job of a Supreme Court justice is to look into this clause, Article 1, Section 8, and the various subsections, and find out whether or not Congress has certain powers. You have very few rights in the Constitution that are ever specified. So in this document, here you see the essential rights that a person is given through the Constitution, and it says, the privilege of the writ of habeas corpus shall not be suspended. Habeas corpus means to produce the body. So if you're arrested, you're allowed to go to an independent judge. And then it says, no bill of attainder or ex post facto law shall be passed. Literally, these are the civil rights that you're granted in the Constitution. A bill of attainder is a fancy way of saying a law that specifies an individual by name rather than by conduct. So if I said, Jamie Arnold shall not be allowed to do X, that would be a bill of attainder. If I said, no individual is allowed to do X, that would be a law of general application. Ex post facto laws deal with the physics of law, in a sense, that law only operates prospectively. It only operates from the present and into the future. It never legislates for past conduct. So if smoking marijuana today is legal and it becomes illegal tomorrow, you won't be held liable for it being illegal just because you did it prior. And I'm going really fast. I'm trying to anyway. Article 2, this is how you get a president. So Article 1 is by far the longest article in the Constitution and the most explicit. Article 2, the powers of the president, very, very short. It really just tells you who could be president and how you get elected. And you don't get elected by a popular vote. You only get elected by the Electoral College. And the Electoral College, the electors in the Electoral College are selected by the legislatures in the state governments, not by the federal government. And finally, you get to Article 3 here, which is how you get a Supreme Court. So again, Article 3, like Articles 1 and 2, Article 3 begins, the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time ordain. So the executive branch, which is the FBI, the police, all of that, they're not your judges. They enforce the law. Congress makes the law. The president enforces the law, and the judiciary interprets the law. There are no other rights specified in this Constitution explicitly. So when the Constitution is finished and being written, there's a great argument between the Federalists and the Anti-Federalists over whether or not this Constitution should have had a Bill of Rights attached to it. In other words, a list of the rights that a person might have. And they said, okay, as soon as we pass the Constitution, the very first thing that the first Congress will do is try to pass a Bill of Rights. And the Bill of Rights is part of the Constitution now because it is the first 10 amendments to the Constitution. So the Bill of Rights are amendments. In other words, they're correctives to the Constitution. And you may want to know that the Bill of Rights, which is commonly referred to as the first 10 amendments to the Constitution, 15 were proposed, 13 by Madison to the United States Congress, 13 came out of the Congress and were passed along to the states, 10 were ratified by the states and became the Bill of Rights, until the 27th Amendment under Bill Clinton's term was finally passed, is actually the 11th Amendment. It was one of the original Bill of Rights. And this tells you something too about the construct of law, of who makes the law. Imagine that there's James Madison, George Washington, Thomas Jefferson, and those guys who write the 27th Amendment, and who are, they and every other person who had been alive at the time the 11th Amendment was written were dead by the time it was ratified as the 27th Amendment. Kind of interesting. And that amendment it's a relatively trivial amendment. It just says that Congress can't vote to give itself a raise during its own term. So that's that. So then you get to the Bill of Rights. And I want to make an important point about the Bill of Rights. First 10 amendments. So the First Amendment is the great place to start. It has, which by the way, was not the first amendment to come out of Madison's pen or out of the United States Congress. It was the Third Amendment to come out. Most people think of it as sort of since it's the first, it must be this primary object of importance. It is, but not because it was intended to be. It was intended to be the Third Amendment. So there's 5 freedoms granted in the First Amendment, and this is where religion begins to creep into the conversation, especially around the Supreme Court. It says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So that's the religion clause. It's actually 2 clauses. It says, you won't have an official church or an official religion. And it says that Congress cannot prohibit the free exercise of religion. So this is what you often hear of, where there's supposed to be a wall of separation between church and state. This is the section of the Constitution that sort of gives the impetus for that wall. So 5 freedoms: freedom of religion, freedom of press, freedom of assembly, freedom of petition, and freedom of speech. Those are the 5 freedoms established in the First Amendment. From a legal standpoint, what's crucial though is this right here. Congress shall make no law. So the federal government is the Congress. It doesn't say that the state can't make a law. It doesn't say that Colorado can't make a law, or North Carolina, or any of the original 13 states. The First Amendment, as it was passed in 1789, only pertained to Congress. So what that tells us is states were free to do oppressive things, and they did. We all know very well, and probably not well enough despite knowing it very well, the horrors of the racist nature of our slave heritage. Because states had so much freedom, this idea of states' rights, which is really a misnomer, it should be called states' powers, but states had the power to do things that which if they were done by the federal government would be unconstitutional. So these 10 amendments, which we consider to be so vital and so part of America now, did not exist as a legal document in 1789, in the sense that this document would not have protected you or anyone from intrusions on your personal liberties by states. And slavery is the great example. So let me rush forward for a minute. You're in the late 1700s, and by 1860, Abraham Lincoln is elected president of the United States. Slavery has crept across the South. You have states in the South where more than 50% of the population is enslaved. The Southern states are nervous about Abraham Lincoln. The Civil War breaks out. Gettysburg Address, the Union wins the Civil War, and the response to the Civil Wars, the legal response to the victory by the Union in the Civil War, from a constitutional perspective, is the enactment of the 13th, 14th, and 15th Amendments. So the 13th abolishes slavery. The 14th restricts states from violating your Bill of Rights. And the 15th deals with black men having the right to vote. So what happens here with this Bill of Rights is when you get to the 14th Amendment, you have a pretty simple looking document. And this is going to answer most of the questions that people have about what does it mean to have Amy Coney Barrett replace Ruth Bader Ginsburg. So here's what the 14th Amendment says. First of all, it gives us this. We have no idea prior to this document who is a citizen of the United States or who is a citizen of a state. It's a haphazard, crazy quilt approach. There's nothing in the Constitution that defines it. And here, the 14th Amendment tries to correct it. And it says, first of all persons born or naturalized in the United States are citizens of the United States and the states wherein they reside. So you begin immediately dealing with the citizenship question, and that's vital because prior to the Civil War, we had a terrible decision by the United States Supreme Court, which you've all heard of, called Dred Scott. Dred Scott is the story of a doctor in the United States Army who had a slave named Dred Scott, and when this doctor and his slave moved to the north, Dred Scott was on a northern base. He fell in love. He met a woman. They got married. The doctor wanted to move back to the South. Dred Scott brought a lawsuit in federal court, got all the way to the United States Supreme Court. And the United States Supreme Court said, blacks have no rights. And it wasn't just limited to slaves, that blacks, in the language of the Supreme Court opinion, this is published, this isn't my paraphrase, are an inferior race, always intended to be excluded from the people who comprise that statement, we the people of the United States, right? Not to be included in the social contract of the Constitution. So we cure that problem after the Civil War by saying, you know what? If you're here, you're a citizen. And not only that, by the way, wake up, Georgia, they're now citizens of your state too, right? It's citizens of the United States and the state wherein they reside. So suddenly the political nature of the entire South changed. Suddenly they were going to be outvoted. And blacks were going to run for election and all of the things that correctly disrupted the established order of the South. But here's where you get the Ruth Bader Ginsburg, Amy Coney Barrett questions. Is here it says, no state shall make or enforce any law which shall abridge the privileges and immunities of citizens of the United States. And here's the crucial section, nor shall any state deprive any person of life, liberty, or property without due process of law. So when I showed you the First Amendment, I showed you, it says Congress shall make no law. The 14th Amendment corrects the First Amendment and the rest of the Constitution, and it says, nor shall any state deprive any person of life, liberty, or property without due process of law. And the second crucial thing that the 14th Amendment does is this section, nor deny any person within its jurisdiction equal protection of the laws. So two things, it gives all persons the protections of liberty and equality at the state level. So this is the entire march of social history in the United States really begins after the enactment of the 14th Amendment. The question becomes, what does the word liberty mean? And the question becomes, what does the word equal mean? And this is what the country through the lens of the United States Supreme Court, begins to modulate for well over 100 years, right? From the late 1860s to the present. So does liberty include the right to marriage? Does equality mean not going to a segregated school? Does liberty include other essential rights beyond marriage, right? The right to engage in consensual sexual activity without it being criminalized with another human being of the same sex, right? So same-sex activities. And what you get is the court decided this early on. The court said, we're not going to tell you generally what the definition of liberty is, nor are we going to tell you generally what the definition of equality is. Instead, we're going to do it on a case-by-case basis. Every time a case comes up, we're going to decide, and we're going to look at, in particular, laws or rights that are part of a well-ordered and established country. And they looked at the Bill of Rights and they said, we are going to incorporate, a word that just means to bring into the body. We are going to incorporate through the 14th Amendment, the Bill of Rights and apply them to the states. So almost all of the rights listed in the Bill of Rights have now been incorporated and applied to the states. So we talked about the 5 freedoms in the First Amendment, but remember the Bill of Rights also includes the 4th, the 5th, the 6th, and the 8th Amendments that all deal with rights of the criminally accused. So the right to be tried by a jury, the right to a speedy trial, the right to have a lawyer present, the right to have a jury of your peers, the right not to testify against yourself, the right to be free of cruel and unusual punishments. Those all come through to protect citizens of the states against their own states through this word, liberty, in the 14th Amendment. And we get to equal in a similar way. Shortly, well, not that shortly after, but in one of the earlier cases after the enactment of the 14th Amendment, you get a case many have heard of called Plessy versus Ferguson. Plessy versus Ferguson is a case involving a gentleman who was traveling on a train in Louisiana. There was a law passed by the Louisiana legislature that had separate rail cars for blacks and separate rail cars for whites. The definition of being black was that one of your 8 grandparents was black. So you could be 7/8 white and you would be treated as though you were black. So it's a very strange sort of construct of social equality. And between Plessy versus Ferguson and Brown versus Board of Education, separate but equal was the law of the land. So as long as you had a black water fountain, you could keep blacks and whites separate. So that's how you got black beaches, black pools, black bathrooms, black trains, black buses, all the way up through Justice Thurgood Marshall. For example, Justice Thurgood Marshall was he's a young black person who his parents named him Thoroughly Good. It's a beautiful name. And tried to get into the University of Maryland Law School and was kept out on the basis of race. Joined the NAACP, worked on a number of NAACP cases, all the way up and through Brown versus Board of Education. He has 27 wins before the United States Supreme Court out of 32 cases. He brings Brown versus Board of Education through the NAACP, National Association for the Advancement of Colored Persons, to the United States Supreme Court. And he's arguing this case against one of the most preeminent lawyers in the nation, a former candidate for president of the United States. There is a Supreme Court justice at the time, I believe his name was Vinson, V-I-N-S-O-N, and the case gets argued by to the Supreme Court, and at the end, the lawyer for the other side, for the state, says, I think we have it won, either 5-4 or at best, at worst, 6-3. In other words, segregation will continue to be the law of the land. The rules of Plessy versus Ferguson will continue. And a remarkable thing happens. The Chief Justice dies. Eisenhower is president, and he had brokered a deal with to win the nomination of the Republican Party. And as part of the deal he struck, it was that he would name Earl Warren, who was a California attorney. He had been governor, he had been a prosecutor, had been considered as a vice presidential candidate, and Eisenhower had promised him the nomination. And next thing you know, Earl Warren becomes Chief Justice of the United States Supreme Court. They call the case back for rehearing. Chief Justice Earl Warren does what he does. He's an extremely political guy, and he lobbies all of the judges patiently and calmly, and he restates the issue as a moral imperative, that segregation is immoral. It, by its very nature, stamps minorities with a badge of inferiority, and he interprets equal as meaning no segregation. Ruth Bader Ginsburg, she comes along and she does much the same things that Thurgood Marshall. She follows quite the same model as Thurgood Marshall follows. The problem here is that when we have this word equal as an equal protection, that that the Supreme Court has said, when it comes to racial matters, we are going to use a really high standard of scrutiny. In other words, in order to make a racial classification between individuals, we're going to hold the government the power to strict scrutiny. But when it comes to women, we're going to have an intermediate standard. In other words, the government doesn't have to show quite so much to discriminate against women. So what you have is this problem. And this gets to the question of the Supreme Court and Amy Coney Barrett. The question is, how do you read language? How do you read these words? According to Amy Coney Barrett, when she's going through the confirmation process, and I think it would sound like I'm picking on her, I'm not. This is the standard practice for justices that hold this philosophy. She claims to be an originalist and a textualist. In other words, a person who wants to understand the original meaning behind the words of the Constitution and believes she can glean those on some level from the text itself, and on other levels by looking at secondary sources. So by looking at the Federalist Papers or the laws that were in effect at the time. But here's the problem with being an originalist and a textualist. Just as a methodology, the problem is, whose meaning of the words should count? Is it the people who wrote the words? Is it the people who voted to approve those words? And when did it matter? So if you're looking at the First Amendment and you're saying, what did Madison think, or what did Jefferson think? Does that matter? Does it matter what it meant in 1789 as opposed to what it meant when the 14th Amendment was ratified and those words were then applied to states? Because it implies something completely different. Or what did the word liberty mean, right? What does the word liberty mean? So on the other side of that spectrum, and again, it's Amy Coney Barrett or Clarence Thomas or Antonin Scalia or Judge Alito, right? You could pick 20 of them. On the other side of the spectrum, you might look at Sonia Sotomayor right now, who, if you're a fan of this jurisprudence, that liberal side of jurisprudence, you'd pick her, or prior to her, Ruth Bader Ginsburg. They look at the Constitution as a living document. They try to look into these words and say, what is our current understanding of the word liberty? So let's translate that a little bit. You could look at the Eighth Amendment and say, well, what about cruel and unusual punishment? Cruel is a subjective moral standard anyway. Unusual is, again, it has a sort of time-bound relevancy. Unusual today or unusual in 1789. So as we look at this document as a Supreme Court, how do we decide? Do we decide that the document is a living document? And if so, what are the standards going to be for how we interpret it? Or are we going to look at it as fixed and time-bound? And if so, at what time? So just again on from a synagogue standpoint, from a congregation Beth Evergreen standpoint, I will tell you that we have had just 8 Jewish Supreme Court justices. They came along fairly late in the whole process. And we currently have 2 on the court. We currently have Elena Kagan and Stephen Breyer, 2 Jewish justices on the court, 3 when we had Ruth Bader Ginsburg. So I've been talking longer than I should have. I'm so sorry, but that's the best I could do tonight.
Wow, thanks, Rich, for what a helpful context and frame. One of the things that you had spoken about with me when we were putting this together was that we use the expressions conservative and liberal to speak about politicians and political ideologies. You had mentioned that we should be careful when we use those terms relative to judges. Can you just reiterate why that is the case again?
Yep, thank you for bringing that up. So conservative and liberal, you know, on the political side, you know, that has to do with your, you know, sort of orientation towards the brand of the parties that we have. Whatever you think conservative means as a Republican brand, or whatever you think liberal means as a, you know, Democrat brand or a progressive brand, you know, those are sort of political questions. When justices use that, when we use that as academics in jurisprudence, we think really much more about the style of interpretation. So a conservative justice is not one whose politics are necessarily conservative, but who rather thinks that the Constitution has a fixed and specific meaning, an orthodoxy, if you will, versus a liberal justice who thinks that the Constitution is a living, evolving document. It's a social contract that exists now between the government and all the people today. So a Reconstructionist justice versus an Orthodox justice, if you want to transpose a different metaphor into it. And you know, a lot of cases are decided 9-0. I was reading a case last night. I think it was a 6-3 decision, and Scalia and Ginsburg were on the same side of the case. Clarence Thomas was on the other side of the case. You know, it's, I guess Sandra Day O'Connor was on the other side of the case, right? So, you know, they're still sort of fluid brands. And in politics, you often don't see them as being so fluid, right? The Republicans vote the straight ticket, or the Democrats will vote the straight ticket. On the Supreme Court, I see the justices moving back and forth. I'm a member of a geeky group called SCOTUS blog. SCOTUS is Supreme Court of the US, and we have a division of it called Fantasy SCOTUS, which, like, be careful if you're married and you're playing Fantasy SCOTUS, you know, you could get caught. All it is they list every single case that's coming up before the Supreme Court. There's about 300 a year. And then they list the 9 justices, and you predict the votes, you predict the outcomes of how they're going to vote, and you keep score. Like, it's a little competition amongst people like me who try to figure out what case outcomes are going to be. And often you're, you know, surprisingly number of times you're correct, and surprising number of times the justices agree with each other. So Jamie, I think you had wanted me also to talk about what it means to have Gorsuch, Kavanaugh, Amy Coney Barrett having joined the court during the Trump administration.
Yeah, I do, and the other phrase that we hear a lot is this idea of activist judges. That might be helpful to hear your take on. But before you respond, I just want to invite everyone who's on the call to put a question or a comment in the chat. So the chat icon is at the bottom of the screen. Typically, you just click on it. There's one. It looks like somebody put in here. Rich, what are your thoughts on a baker using the Constitution to protect their right to refuse to provide a service to same-sex couple? So maybe we'll hold on the specific cases for a moment just to address the current justices and their appointments to the Supreme Court under the Trump administration, and how we might look at that.
Right. So so let's talk about an activist judge for a minute. You have these competing ideas in the government, right? Not in a right or wrong sense, but these competing currents. When you think about democracy, this idea of people power, embedded in that idea is that you have a sense that it's good and it's right to have people vote, make laws, and to govern themselves. When you look at the Bill of Rights, for example, it is not a majoritarian document. It's counter-trending to the Article 1 powers. So Article 1 powers are powers where 435 people get together and they try to do, a popularity contest. They've got to run every 2 years, so they got to stay popular if they want to get reelected. So not surprising that you have a very majoritarian sentiment coming out of the United States Congress, especially out of the House of Representatives, less so out of the United States Senate. Which, by the way, before I go tonight, let me talk to you about the Electoral College. Okay, remind me, Jamie. So you have the majoritarian sentiment coming out of the Congress. The Bill of Rights is really the province of the Supreme Court, and that's anti-majoritarian. When it says you have free speech, or freedom of the press, or freedom of religion, it means that you don't have to be popular at all. You could take the most reprehensible ideas and have the right to publish them, or have the right to assemble and promote them. So those are the Nazi parties marching in Skokie, Illinois, or the KKK holding their Klan rallies. And the job, believe it or not, of the Supreme Court is to protect the rights of the unpopular, those rights of people that are, under Jefferson's terminology, unalienable or inalienable, because those minority rights, those unpopular rights, and unpopular in the sense that they're not going to necessarily hold sway in Congress, are not going to be protected. And so what the founders were afraid of is as much the tyranny of a majority as they were of the tyranny of King George. So the Bill of Rights and the Supreme Court protects against the tyranny of the majority. It's a really important function. And it's why Supreme Court justices are life appointed, right? And only can be impeached if they do, a felony or something like that. So an activist judge, the label activist judge, is applied, and I think incorrectly, to courts that overturn majoritarian laws. In other words, the idea that a court will strike down a law of Congress that's passed by Congress, passed by the Senate, signed into law by the president. That's what activist judges do. They strike down majoritarian laws. My answer to that is, well, that's their job. If the Constitution says that people have the right to unpopular opinions and to express them publicly and to organize, we want the Supreme Court to do exactly that. That's what an activist court does. I think sometimes the word activist court then becomes appropriated because it's a convenient label to say, well, this is expanding the rights of, let's say in the Obergefell case of, my talk's here, of the Obergefell case, the gay marriage case. People will call that an activist court. I don't think of that as an activist court, though. I think of that as a court that's having an interpretive process of trying to figure out what the word liberty means, or equality.
You want to go back to the appointments of the Trump administration and maybe the anecdote you mentioned about, we can't necessarily predict the.
So the question when it comes to the appointment of the 3 new justices, when we talk about sort of the political effect of a conservative or originalist justice, what you're really seeing is tipping the scales of federalism. So when you get an opinion out of the court like Obergefell, which allows same-sex marriage as a constitutional right and eliminates the discrimination, what you're really saying is this Supreme Court is now going to legislate constitutional legislation over all 50 states, right? So you're really seeing what is a shift in the idea of federalism, that idea that there are some things that are the unique province of states and some things that are the unique province of the federal government, and some areas where those two provinces might overlap. When you look at the nomination and the appointment of what people will call conservative, or you may call an originalist judge, they tend to be appointees that favor a reduction in the scope of powers exercised by the federal government and an increase in power being exercised at the state level. And remember that that's why the country fought the Civil War, right? That's what happened was robust federalism with robust states' rights did not work out very well. And the whole march of courts, you know, the Warren Court that I mentioned, for example, with Miranda decisions, or Mapp versus Ohio, or Brown versus Board of Education, or any of the other cases you might have heard of, Loving versus Virginia, right? Abolishing the anti-miscegenation laws that restricted blacks and whites from marrying upon with criminal convictions. What you're seeing amongst these conservative justices is a return of power at the state level and forbearance in the exercise of that power at the federal level. So what you'll see in it, I think, is, for, at least in the areas that this group might be most interested in, some social issues, how does that affect Roe versus Wade, right? How does that affect the right to an abortion? Or how does that affect voting rights? Or how does that affect the gay marriage decision? And the answer is that the conservative or originalist justices see those decisions as residing at the state level rather than the federal level. So they may not opine whether or not abortion is moral or immoral. Rather, they'll say, or is a fundamental right or isn't a fundamental right. They'll say that is a question reserved for the states. It is not a place for the federal government or the federal constitution to impose itself. All the states have their own state constitutions. All the states have their own state legislatures. Let them figure it out. So I think that's what that's what we're bound to see now, is this idea couched in the name of federalism, that you'll see a retreat back away from a robust federal government to a more state-centered approach. And you're already seeing it. I think it's certainly coming true. That, Jamie, you passed around an opinion the other day, or at least sent me a copy or a reference to it. You know, we know pretty well where these three new justices fall on the ideological spectrum. And there's no doubt that you have, at best, a 5-4 court. You probably have a 6-3 court. The tide has shifted, and it will remain shifted for quite some time.
There's a question here from Lois about this idea of packing the court, of adding more justices to the court. Thoughts about that?
Sure. So, hi Lois, by the way. Packing the court. I just don't think it's going to happen. 9 has become, sort of a entrenched number that seems to work pretty well. I don't think you're going to see any courts, any movement by the political party or parties to change that at all. There is no definition in the Constitution about the number of justices on the Supreme Court. You could have one. The only appointment to the Supreme Court that the Constitution makes is the Chief Justice. We've had fewer than 9 before. Franklin Delano Roosevelt, when he didn't like, at a time when he was trying to promote progressive legislation, particularly workers' rights, trying to move the country out of the Depression. A lot of his progressive legislation around economic rights were being struck down, and he threatened to pack the court. He threatened to move it from 9 to 15. It's famous. One justice on the 9-member bench started switching his votes. They called it the switch in time that saved 9. Yeah, and I think that's true. I don't think Biden has any appetite to be a court packer. He'll live with the 6-3 decisions before he packs the court.
Marilyn asks if the founding fathers in any way addressed or gave hints about their about the issue of the static versus involving document, that the Constitution and the Bill of Rights, if they expected the bill to last the Bills of Rights to last hundreds of years without amendment, etc.?
Yeah, that, Marilyn, I think is a great question. I'm trying to think of a specific primary source example where something might have been written about that. I would answer the question in two distinct ways. One is that the country that they envisioned did not exist until the 14th Amendment. And I mean, in other words, we're two totally different countries. I can't even truly think of the Constitution in a pre-14th Amendment context, because everything we do now is entirely different and is modulated through the scope of the 14th Amendment, that liberty provision and that equal protection provision. I say everything, you know, there's issues that we haven't talked about that are more isolated, but on the important social issues of the day, that is certainly true. So Jefferson believed in a robust states' rights-oriented federalism where these questions were not being decided by the federal government, they were being decided by local governments. And in fact, you know, in his day, in Washington's day, if you had asked someone, it'd be like going to Europe today and asking an Italian, where are you from? He wouldn't say, oh, I'm a European. He'd say, I'm an Italian, or she'd say, I'm an Italian, right? I'm a Frenchman. That's what the United States was like. These 13 colonies were much more about being a New Yorker or a Virginian. And this document that you're seeing in front of you, including the Bill of Rights, was much more like the European Union than the Constitution that you are familiar with living under. But the second half of my question is, I don't think they were afraid at all. And the evidence, Marilyn, that I would give to you to show you that I think they are fearless is between 1776 and 1787. These guys were living under a completely different constitution called the Articles of Confederation. It had no president, it had no judiciary, it had no Bill of Rights whatsoever. It was a flawed document, but it was the Constitution of the United States called the Articles of Confederation. They got together, and in a couple of months in Philadelphia, not even representing all the states at the time, scrapped the entire thing. I don't think they were fearful at all of the pen. I don't think they were fearful at all of change. People say they made the document difficult to amend. I don't know. The very first thing the very first Congress did was pass 10 amendments. So like, I consider ourselves weak by comparison, right? We've only done 17 since. So I think they'd be disappointed we don't change. I don't think they'd be conservative whatsoever.
Nice. The three sort of cases that are mentioned, you can, the one I described before about the protecting businesses, you know, refusing to provide services to same-sex couple. The other is on what grounds are there to take election results to the Supreme Court in terms of the presidential election, and then Obamacare.
Right. So I'll start with the bakery case, right? It's a Colorado case. This follows a long line of questions. So in the beginning, I showed you, I said the federal government has limited power, and you've got to look under Article 1, Section 8, and go down the list and figure it out. So the first question would be, do you have private rights in this country? So in your own houses, are you free to discriminate? Are you free to decide you're not going to serve someone for any kind of reason you might have, many of which, you know, people could say are immoral reasons? Could a private local restaurant refuse service to people based on its own religious beliefs or its own moral beliefs or its own prejudices, whatever it would happen to be? The First Amendment does not say no person shall deny any other person the free exercise of their religion, free speech, free assembly. It says Congress shall not. And the 14th Amendment doesn't say no person or no business can discriminate. It says no state shall discriminate. So these documents define the relationship between citizens and the state, and it tells the state, don't discriminate. So don't discriminate in your hiring practices in the public school system, and don't discriminate in the United States military, right? Places where the public sphere is. But it doesn't tell you that you can't discriminate in your own business. You know, and we look at Congregation Beth Evergreen, we probably have, or certainly many synagogues and churches and the like, have all sorts of things. They only want to let Catholics into the Catholic Church, right? Right. It's kind of a basic question. And so when it comes to how does the government get involved in regulating the discrimination of same-sex couples in places of public accommodations, the answer is if the Congress finds that the business affects interstate commerce. So there's a great case out of Atlanta. Was it Susie that asked this question? I think it might have been. This case grows out of a Heart of Atlanta motel case where the Congress said, listen, hotels involve travelers. Travelers move from state to state. People moving from state to state is all about interstate commerce. Therefore, we're going through the Civil Rights Act of 1964, we're going to stop discrimination, racial discrimination in public accommodations. The other is that states under states' rights theory have broad powers to do all sorts of things to make things better. So here in Colorado, I would say that you have legitimate tension between a state enacting a law that says we disfavor discrimination for all sorts of reasons. Forget the moral reasons, though. Usually the Constitution is not talking about morality. It's usually talking about economics. And it says it's bad for business to discriminate. And then you have the question of whether or not someone has religious freedom to discriminate. So that's what the cases begin to look like, is whether the state can find a source of power to justify its behavior. And I'll give you one example of where the court came out. So the Violence Against Women's Act it's probably 20 years old by now, or 25 years, trying to stop the scourge of domestic violence and domestic abuse, created federal penalties for domestic violence and domestic abuse across the entire United States of America. If you can hear that tearing, that's my dog tearing my pair of jeans right now. Not the ones I'm wearing, though. Lincoln, stop. The Congress passed this law, and it did a similar thing about gun violence. It had gun-free zones around schools. And the Congress justified those laws not based on the immorality of domestic violence or the scourge of gun violence. They justified it based on the Commerce Clause, that violence against women is bad for business. That's what Congress said in its legislative intent, because it had to find a source of power. Well, the United States Supreme Court struck that down. They said, yeah, listen, while we may have agreement with the noble intent of the legislation, Congress doesn't have that power. So to answer Susie's question, I think a little more directly is, there's two questions. One is it a legitimate federal power or is it a legitimate state power? And here I think the state has legitimate reasons to enforce anti-discrimination laws within its own borders, even if it's only because it's bad for business. But this is a different answer, by the way, than saying, but a gay person has a right to assert against a private party. I think a gay person has a right to assert against a public entity, in other words, against a school district or a fire department or a police department, but not necessarily against a private enterprise.
Susie, did you want to ask a follow-up, or don't forget to unmute if you're good.
I do have a follow-up. I'll let Susie go ahead.
No, go ahead, Rich. I really, that's not quite the I was expecting. I thought there would be more, I don't know, more protection, right? I'm all for the, the same-sex couple being able to get what they want. But I hear what you're saying. Yeah, thank you. Thank you for such a thorough explanation.
Yeah, and Anne, remember, I'm not giving my personal opinion. I'm predicting the outcome of what courts will do.
Right.
No, so my question as a follow-up to that was, is it interpretation of, I mean, the federal government theoretically protects when it's a civil rights matter, right? The federal government becomes involved. So the question in my mind is who makes the interpretation as to whether it is a civil rights issue in that particular case. And I'm not stating my opinion on it because it's probably contradictory to a lot of other people's, but and whose civil rights are being protected, the owner of the business or the customers. So where is that where the Supreme Court gets involved and makes the decision as to whether this is a civil rights issue or not? Or I'm sorry, I'm not stating that very well, but.
No, first of all, I think you are stating it well, and it's a hard position to state. What I would suggest to you, Anne, is that you add one element into the question, and that is the question of equality. So remember when I showed you the 14th Amendment, I said no state shall deny any person life, liberty, or property, nor shall any state deny equal protection, right? When you have a guy in a bakery wanting to buy a cake, you have two rights. You have someone who's claiming a right to do business and to enter into contracts or agreements or socialize or assemble with anyone he wants. And you have another person sort of asserting the same things. In a way, they're both falling within the First Amendment. The question becomes really whether or not the government can stop discrimination. And stopping discrimination is a real core value of governments. So it becomes, balancing between non-discrimination and the enforcement of rights. Generally, what you have when you get to civil rights issues is principles of non-discrimination. In other words, if you say everyone can participate in X activity, whatever X is, that works, right? The government's going to be able to do that and regulate it. Everyone can drive a car, and all they have to do is make sure they stay under 55 miles an hour, right? They don't exceed the speed limit. Well, that's great. That's going to discriminate against a lot of people who want to go 60 miles an hour, right? You may be one of those people. If they say, well, everyone has to stay under 55 miles an hour except white males, they can go 65, right? Or Asian people have to go 45, right? Once the government starts to make discriminations, then they tend to be speaking about civil rights. That's the language of civil rights. So everyone can go into a store and buy a cake. That's a law of general application. It applies to everyone. When it becomes a violation of civil rights becomes when the government tolerates discrimination, right? That's what's happening there. They both have a natural right, or what we call a liberty, under the First Amendment to do business, to enter into contracts, but the question becomes a question of rights when you introduce the idea of discrimination. Does that make sense?
Yeah, thank you. Rich, do you want to chime in on the prospects of challenge to election results going to the Supreme Court? That's from Mindy.
Hi, Mindy. Hey, Mindy, take yourself off mute for a second. Are you off? While you're getting your mute button unmuted.
Yes, I'm off.
When the Constitution was ratified and George Washington was elected president, there were about 4 million people in the country. About 38,000 of them voted. And about 50% of the states had some version of some kind of what you might call a popular vote. In other words, where citizens could go to a ballot box and cast a ballot. The others, all of those votes were taken by the state legislatures. When Al Gore brought his case against George Bush in the famous 2000 election, and Bush v. Gore made its way all the way to the United States Supreme Court. The Supreme Court confirmed something that people in my little neck of the woods already knew, which was you do not have a constitutional right to vote for president. None whatsoever. All of you could lose that right with no objection at all from the United States Supreme Court. So voting is not a fundamental liberty, and it's not protected by the Constitution. So you're all shocked by that, and you should be. The Constitution sets up the rules of the game, and it says there's going to be an electoral college. And it says that the electors in the electoral college are going to be chosen according to rules set up by state legislatures. So if the state legislature decides it's going to give individuals the right to vote in an election to choose the electors to go to the electoral college, so be it. Once that happens, all of the protections of the Constitution against non-discrimination take place. Women can vote. Anyone over the age of 18 can vote. There will be no poll tax and no racial discrimination in a vote. But it's up to the state to give you the right to vote. So back to that point I was trying to make before about this idea of a robust federalism, of a states' rights versus federal rights kind of world. Voting is state by state by state. You have 50 different systems, 50 different ways that can be chosen to select electors for the Electoral College. Do I think this election will be overturned? I'd say there are no indications whatsoever by any credible academics or political scientists that I'm aware of that tell me that this is going to go to the Supreme Court and get overturned. This is, you can start making t-shirts and bumper stickers for President Biden.
No, and so based on, your whole thing about some of the people that Trump and other Republicans have put in, if they're more originalists, and the original thing is elections are run by the state, then I don't understand where there's any grounds to take anything about the election to the Supreme Court.
Can you say it one more time?
Well, based on what you've said about originalists being more more federal versus states' rights.
Yep.
And if states have the power to set up elections and run elections, I'm just curious what kind of grounds anybody might use to take an election to the Supreme Court and say the Supreme Court will decide. If they're basically going to say it's a state's issue, and if the Supreme Court in Michigan, Wisconsin, Georgia have said we're done, like, what kind of grounds are there to even think about the national Supreme Court entertaining any kind of discussion of this case?
Mindy, it's a beautiful question. And let me tell you, it's been answered, and it was answered in Bush v. Gore. So in Bush v. Gore, Gore wanted a recount. Gore went to the local trial courts. He went up through the state court of appeal. He went all the way to the Florida State Supreme Court. Florida State Supreme Court interpreted Florida law and said, okay, you're going to recount the votes. Bush then, right, this is so interesting how conservative politics and conservative justices don't align. So the conservative Republican political candidate takes the case up to the United States Supreme Court, which, by the way, rings very true to the current context, where his father, Senior Bush, had appointed justices that were on that very Supreme Court. And by the way, his brother was the governor of the state of Florida at the time, so it's really an all in the family kind of deal. But it answers Mindy's question perfectly. It says, hey, wait a minute. If Rich is right, and voting is a states' rights issue, and every state can decide itself, and conservative justices, originalist justices, think that activist courts should keep their hands off of state decisions, then why would the Supreme Court ever hear a case involving a local state election? And the answer is simply this, that first of all, they had very motivated reasoning, right? They really wanted to be involved. And the principle at stake in Bush v. Gore that they found a constitutional provision in was the idea that every vote should be counted equally. And somehow or other, when they looked at Florida, they decided that selective hand recounts would not assure equal protection. So again, that 14th Amendment, second provision in the 14th Amendment that I showed you on equal protection, it was decided by the Supreme Court that counting every ballot in this by hand way somehow introduced an arbitrariness that took away the one man, one vote, or one person, one vote principle of voting that's established in the Constitution or embedded somehow in the Constitution. And that's how it got there. So Mindy's point is brilliant in that unless Trump can find some similar constitutional provision to show some violation of a constitutional value, he's not going to get to the Supreme Court.
Thank you.
Sure. So when it comes to democracy and representative government, a lot of people will ask about the Electoral College. And the Electoral College is made up of 538 individuals. And that denominator, 538, equals 435 members of the House of Representatives. So that's a very equal distribution of the popular vote if it were translated, right? Because all those congressional districts are roughly the same size. And then each state gets an elector for its United States senator. So that's 2 per. And what that means is the 30+ million people in California have 2 electors relating to their senators. And Wyoming, which has, I don't know, 1 million or something, gets 2 as well. So the reason the popular vote and the electoral vote skew so often is that small states are favored by virtue of the fact that 100 of the 535 are represented by the United States Senate. This is a leftover of this whole notion of states' rights, that each state should count equally in the United States Senate. I'm actually going to get to the Supreme Court here. By the way, I told you 538, and I've only accounted for 535. The other 3 relate to the District of Columbia, which gets the same number as the minimum state. So they will get 2 senators and 1 House of Representatives. So that's how you get to 538. The answer on the Supreme Court, and really the questions that you are all struggling with, I'm sure, is how do you get a liberal population? 80 million Democrats vote for Joe Biden, and 64 million or something vote for Donald Trump. You get an enormous discrepancy in the number of votes, and yet you have a United States Senate that confirms. And the answer is the United States Senate is not proportionally representative of the population. And because it includes 1/5 of the total votes roughly in the Electoral College is similarly conservative. So your constitutional system is giving you a conservative court because we have so many small states in the South, which, by the way, are historically prejudiced through slavery, right? They're the same states that did not enact the Equal Rights Amendment, right? And you can ask yourself the similar question: why did it take so long to get the 19th Amendment, giving women the right to vote, or abolishing discrimination against women with respect to the right to vote, when Black men got it in the 15th Amendment? And the answer to that is it takes forever to amend the Constitution because you got to get all of those small Southern states to vote along with it in order to get to the 3/4 number that you need in order to amend the Constitution. So you're seeing that what I said before about the European Union, right? People thought of themselves as Virginians. You see that reflected in the United States Senate. They don't care that California or New York or New Jersey or what have you have so many people. All they care about is their state badge of identity. They're not representing the whole country. You see that in the Electoral College because of the way the 535 is composed. You see it in the United States Senate, and therefore you see it in the United States Supreme Court because those justices come out of the Senate, right? The president nominates to the Senate. The president doesn't nominate to the House of Representatives, doesn't represent to the Congress.
All right, so there's a question from Jay about Obamacare and how it fits into the conservative liberal trains of thought on the court. We're running short on time, so I'm going to give you the questions and you can pick And then there's a question from Joan about the relative inexperience of federal judges recently appointed to the lower courts, a few years out of law school, and the power given to the lower federal courts. And then Catherine offers a question about international law and US historically not respecting international law, and especially human rights. And do you anticipate this ever changing, evolving, and in light of the global economy?
Okay, so let's start with Jay's question on Obamacare. You know, they did away with the mandate. In other words, the penalty that if you don't have Obamacare, then they're going to surcharge you on the tax. And the theory on the Obamacare case was essentially that it's an act that is established because of the power to tax. So remember, I showed you Article 1, Section 8, and the very first one was to lay and collect taxes. So the thesis is that Obamacare stems out of that taxing provision. And then when the mandate gets stripped out of it, that the basic power of that 1,000-page bill goes away. So there's no longer a Article 1, Section 8 power to give it constitutional basis. I don't know how that argument would have played out, 3 years ago when we were fighting it. But at this point in time, you introduce a second problem, a second constitutional problem, and that's the problem of vesting. So once a person has a vested right, it becomes difficult to take that right away. So you think about the gay marriage cases, right? Once you have your marriage certificate, suddenly you have a vested right. And it becomes a different question of decoupling a person from that right. I'm hopeful that the Affordable Care Act, Obamacare, remains a viable piece of legislation due to the fact that it has become a vested right. So even decoupled from its original power, I think people are going to claim a vested right in it. But more importantly than that, I have a strong hunch that it'll start to become revived through new congressional legislation, through new executive orders, and who knows, maybe something, it's hard to predict the United States Senate. We'll see what happens in Georgia in I guess a week or two, right? But I'm more optimistic about Obamacare than I am about Roe v. Wade. Which, and I'm not drawing any equivalence there. I'm just saying in terms of things that are going to be overturned, good chance you'll see Obamacare get saved.
Thank you.
And then the next question was, what was the next one? Federal judges without experience.
Judges, lower courts, lack of experience.
Yeah, so that is also a great question. When you look at the federal court system, I think having experienced trial court judges who are experienced lawyers make a lot of sense to me, because you need to know the rules of civil procedure, how to work with evidence, how courtrooms actually operate, those sorts of things. So I don't mind inexperienced judges on the lower levels of the federal bench when they're trial lawyers, provided they have good trial experience. But Joan, one thing I can tell you is that you don't need to have been a judge to be a Supreme Court justice. And we have examples of, currently, I don't think Elena Kagan has served as a judge, nor even as an active lawyer prior to her ascension to the court as a Supreme Court justice. So I don't know, I guess my personal experience and bias is it's good to go to law school and figure this stuff out and practice and all of that to have a good academic career. I don't mind if people have not been judges or lawyers as much as if they have not been sort of academically dialed up to the kinds of things that I've been talking about tonight, right? I think history matters, philosophy matters, data science matters, almost more than whether you can cobble together a good argument in a courtroom to a jury. What was the third question?
The third one from Catherine about international law and the US vis-a-vis international human rights. And also David Froman has a question as well about the Justice Department and why under the executive branch, excluding the Supreme Court. And how difficult would it be to correct this?
All right. So a Justice Department under Article 2 rather than Article 3 question, and
International.
International. Yeah, sure. Right. So yeah, this international question is a terrific question. The answer goes back to a Jamie styled worldview, which is jurisdiction is, again, two words, right? Like demos kratia. Jurisdiction. So where does the law speak? Juris is law, diction is like dictionary speech. When it comes to international law, the question is, who is the sovereign of this thing? So here in the United States, we know where Colorado is, and so we know the jurisdiction of Colorado, and we know the US borders, so we know the jurisdiction of US borders. But when we talk about international law, and Natalie Terrasser can correct me too, you're really talking about some more abstract ideas around kind of accepted norms of behavior, and you're talking about legislative ideas that are established through treaties, right? So the countries negotiate, and then there's a treaty, and then your country adopts the treaty, essentially by contract or by treaty, agrees to be bound by it. The United States has had a fairly good history of engaging with, broadly speaking, international human rights, right? We have the United Nations in New York. We have the Universal Declaration of Human Rights that American lawyers were a substantial part of creating and adopting. We've been signatories to the International Covenant on Civil and Political Rights. You know, so we do have protections and we do participate. What we don't do a very good job at, in my opinion, is aligning our political actions in the same direction as our beliefs about international human rights. So, you know, we have a staunch allegiance with Saudi Arabia. Saudi Arabia is a theocracy. It, you know, practices religious discrimination. It, you know, has a terrible track record on all sorts of different human rights issues. And yet, you know, they're an enormous trading partner of ours. They're an enormous strategic military ally of ours. They buy tons of our military equipment. We never sanction them. So, you know, if one hopes for change in international human rights, I think they have to go to the ballot box to achieve it. And the problem is typically when people vote, when they list the primary issues that they're voting on, international human rights doesn't make it to their decisions about congressmen, senators, or presidential candidates. We do have a history, though, and it's an interesting history on the Supreme Court, of finding our way to these international norms. So when we look at, for example, the death penalty cases to decide whether death penalty is cruel and unusual, you'll see the justices writing opinions where they cite international law. They'll say, you know, by the way, in the annals of international law, we're, you know, with the following 2 or 3 countries who practice this barbaric act. And you'll see that crop up in a lot of opinions. And we've had justices, including one of the first Jewish justices, I think the 3rd or 4th Jewish justice, leave the Supreme Court to join the United Nations. So there is some back and forth about that. I doubt it's going to be much of a job for the United States Supreme Court because, again, it sees its jurisdiction, right, where its law speaks, as quite distinctly defined by the Constitution and pertaining to our boundaries as opposed to foreign boundaries.
Well, all right, well, let me give you a minute if you want to respond to David Froman's question about the Justice Department, and then maybe I'll have you wrap up with the story about the justice who started out in the KKK.
Oh my gosh. Yeah, that's a good one. If I understand Dave's question correctly, it's why do we have the Justice Department as a branch of the executive branch? Is that right, Dave? Maybe you'll read that question real quick.
Yeah, I can read it for you. Is it a mistake that the Justice Department was put under the executive branch, Supreme Court excluded? And if so, how difficult would it be to correct this?
Yeah, so that's a great question. And there are sovereigns out there that have a construct like David's talking about, where the judicial branch and the Justice Department are coupled together. I'm a fan of an independent judiciary. I think having the police and the prosecutors falling under the executive branch and doing the job of developing evidence, making prosecutions, doing those sorts of things is important. The Constitution does create shared powers between those two branches. For example, you're protected under the Fourth Amendment from unreasonable search and seizure. And so searches and seizures require the signature of an Article 3 judge, so an Article 3 power coupled with an Article 2 enforcement. So police, if they're going to burst into your house with to search or to seize, they're going to have had a judge or a magistrate sign off in advance. So we do have some separation of powers there. I worry actually about something of the opposite trend, Dave, which is I see a lot of judges being promoted out of the ranks of prosecutors. And so you do get a bit of a group think, especially at the trial bench, of fairly prosecutorially oriented judges. And so I like the way the system is designed right now. I mean, you don't have a lot of choices it's like a trumpet. It only has 3 valves. Out of those 3 valves, I'd rather see the prosecutors live under the executive branch the way that they have. So Jamie asked me a question. I want to close with 2 things, but Jamie asked me about some justices and what I knew about justices before and the difficulty that we have in predicting. And I'll tell you just a brief story that illustrates this point, that when FDR was making an appointment to the bench, he appointed a Southerner out of Alabama named Justice Hugo Black, or then Hugo Black. Hugo Black was a politician and a trial lawyer, nominated to the United States Supreme Court. And during his confirmation process, it was uncovered by, I believe, a New York Times author that Hugo Black had been a member of the KKK. And nonetheless, this member of the KKK becomes confirmed on the United States Supreme Court and becomes something of an antagonist to a Jewish justice, Justice Felix Frankfurter, true name. Frankfurter being rather deferential to power, being a rather conservative justice, Justice Hugo Black being quite the textualist, and understanding that the role of the United States Supreme Court is to defend minorities and protect their constitutional rights. And he writes in dissent over and over and over through probably the first decade of his tenure that Congress is overstepping its power, or that states are overstepping their powers, violating the rights of minorities, particularly Blacks. And he grows to become a voice of the majority, that the court, he ultimately pulls this court along with another fellow, Justice William O. Douglas, later followed by a guy named Brennan, several other fairly liberal justices, that ultimately lead to the Warren Court's expansion of what has been termed in Jamie's vernacular, a more activist court, or a more liberal court, or a court that sees its role under the 14th Amendment as affirming limits on powers by states in favor of individuals' rights. So you get cases like Miranda, or you get Gideon versus Wainwright, where the states have to provide lawyers to indigent defendants facing felony criminal charges in state courts. So my answer is sometimes we don't know what we're getting with these judges. Even Anthony Kennedy, who was the 5th vote in most of the important 5-4 decisions, really, in the 90s through the mid, 2015 or so, cases that expanded social liberties for gay and lesbian couples. Kennedy was, if you were arguing an important civil rights case or civil liberties case to the Supreme Court, you know, between like 1990 and 2010, 2015, you were basically arguing to Justice Anthony Kennedy, a Republican appointee from the Republican Party who became a great liberal voice. Point is this, that I trust often that people will do what they're supposed to do, that they will see their role correctly. If you're in the executive branch, maybe you're going to be running the military, and you're going to just do that job as well as you can. If you're appointed to the United States Supreme Court, regardless of the background you've come from, sitting in that seat tends to inform your judgment that your job is to secure the individual liberties for the people who are represented under We the People. So that's how I'll close that up with my Justice Hugo Black story. But I'll also tell you one thing that I looked up for Jamie today. I was trying to find where are the correlations between Jewish iconography and the Supreme Court. And I was curious to see, I wanted to see how many times I could find Moses at the Supreme Court. And you can find Moses and a bunch of other historic figures and mythical figures as well in the Supreme Court. But on the eastern wall, the eastern exterior wall of the United States Supreme Court, you have three figures that are facing east, right? Where the sun rises is how they are positioned. And Moses is the central of the three figures, and he's holding the 10 Commandments. So these are, all three figures are figures from three great civilizations who are known as great lawgivers. So right there at the United States Supreme Court. And then inside the court on one of the interior walls, on a frieze that's on an interior wall sculpted in, it has him, you can see displayed, he's holding two tablets back to back. On the exterior wall, he's holding both tablets out facing east. Interior, he's holding them both, and you can see inscribed commandments 6 through 10.
Mhm.
So,
Which are the ones that govern human relations, right?
govern human relations.
Exactly. Oh, well, thank you, Rich. Wow. And everyone here for participating, asking some great questions. Well, I'm sure the conversation will continue. I'm sure Rich would be happy to answer any of the questions offline. And if you have other ideas too about programs that were other adult ed opportunities or speakers, or if any of you would like to do some teaching about something, Jay Kramer has been working and sort of heading up the adult ed programming, the Tuesdays with Maureen with me and Eve. And Jay, thank you again for continuing to do that. And in terms of the international, and human rights question, we're planning to do a book club on world poverty in January and February as one of the possible programs. And so please do share your input, and we'll look forward to convening again and doing some more learning together. All right, thanks everyone, and happy Hanukkah, and and thank you again, Rich.
Thank you.
Wonderful.
I'm a cup of coffee away from any of you.
Okay.
Thank you.
Rich.
Bye, you guys.
Thanks, Rich.
Bye.
Thanks, Rich, so much.
Bye. Thank
Thank
you.
you.
Thank you both to Rich and the Rabbi.
Thank you, Fred. Good to hear you.